Well, recognizing that everyone's on their lunch hour probably, and we've got some, a bunch of information to get through, we'll get started. First of all, I want to thank everyone for spending the upcoming hour with Raphael and I. And we would like to acknowledge that we're gathered on the traditional ancestral territory of the Coast Salish peoples, including the Squamish, Tsleil-Waututh, and Musqueam nations. And we're thankful for the opportunity for us at Gowling, Vancouver, to be able to work on these traditional lands. For me and Raphael and other non-Indigenous Canadians, I think land acknowledgements are an important opportunity to reflect on the impacts of colonialism and be accountable to Indigenous people and to thank those who still live and care for the land. And at Gowling WLG in particular, I think we have the privilege of being with a company that mandates inclusion and an obligation to work in cooperation and towards the path of reconciliation with Indigenous peoples. So I just want to briefly mention Raphael and I and our backgrounds. Hopefully you can just Google us and we don't have to go through all the details, but we're both partners in our private client site services group. I practice out of Vancouver. Raphael practices in Ontario and Vancouver. And he is mostly on the solicitor drafting side. I myself mostly on the litigation side. I think both of us take pride being actively involved in our communities. And we appreciate these types of opportunities to have engagement with our clients and with the community. So Raphael in particular, he's been involved as in-house counsel for an insurer and financial institution, and he comes with a really unique set of knowledge that I don't think you'll find elsewhere, really. And he'll touch about some of his learnings and recommendations with an eye to some financial institutions in today's presentation. I myself find myself overly enthusiastic about delving into people's personal disputes, and I'll be talking about some of those situations involving misuse of powers of attorneys that can lead to unnecessary and expensive litigation. So one thing that we're seeing in both of our practices, and you might be seeing in your work, is more and more use of powers of attorney, enduring powers of attorney in BC anyways, which is excellent. But with that comes more opportunity for abuse. And given the kind of interplay of increased rates of dementia and dementia-related diseases, and the huge transfer of wealth of the baby boomers, and of course, family dynamics, this makes it an important issue for us. I mean, personally and professionally, I think it's important for a lot of people to know more about this. So I will turn things over to Raphael. He'll go over an introductory explanation of powers of attorney and talk about the duties and responsibilities of attorneys. Then I'll discuss the misuse of powers of attorneys and how to address that before Raphael wraps things up. So Raphael.
Thanks, Robin, and thank you everyone for joining us. We hope that you find this presentation useful and helpful. And at the end, there's an opportunity for questions at the different sections. So when one of us finishes a section, if you have questions, feel free to pop them in the Q&A and we'll monitor and try to address them so that the presentation is dynamic and is responsive to what you're hearing, the questions you have. So a quick introduction of powers of attorney, and because we're speaking to different audiences in various provinces, I'll try and, to the extent possible, broaden the conversation. Power of attorney, as Roman mentioned, is a popular estate planning tool that increasingly we're seeing being used in the estate planning context. And it's available in all Canadian provinces and territories. It's an instrument, which really means it's a document under which a donor, either an individual or corporation, grants another party the authority to act on that donor's behalf in respect of that donor's, speaking of purely powers of attorney for property or financial, to deal with financial affairs. You're dealing with legal issues, financial affairs of the person, of the donor, or a specific portion of those issues. So you can limit it in terms of subject matter. This is because we're both sitting in BC currently, we're using the BC Act as the basis for the presentation, but happy to discuss for anybody that's in a different province how the language in your Powers of Attorney Act. But generally, powers of attorney, unless there's a contrary intentions demonstrated, an adult's presumed to be capable of making decisions about their financial affairs and understanding the nature and consequence of making or changing or revoking a continuing power of attorney if you're in Ontario or an enduring power of attorney if you're in BC. That adult's way of communicating is not grounds to decide whether the adult is incapable of granting or revoking a power of attorney. So if someone, for example, does not speak English but have granted a power of attorney, it doesn't mean that they don't understand, they don't have the capacity to grant that that power. It just means that you will have to deal with that person in their language to make sure that they're capable of granting that power of attorney. Provide enduring power of attorney or a continuing power of attorney continues regardless of a donor's lack of capacity. So if Raphael for today, I sign my power of attorney and I have capacity today, if that power of attorney is enduring or continuing, it means that that document is still persists in its authority even after I've lost my capacity. The power of attorney terminates upon the donor's incapacity, unless it's enduring or continuing. It terminates on the donor's incapacity or on death. The reason why I wanted to highlight that piece is really a lot of, when we get to the financial institutions discussions, we want to focus on the idea that an enduring or continuing power of attorney is an exception to what the general common law about power of attorney is, right? And that it's statutes that different provincial governments have introduced relating to enduring or continuing power of attorney is what provides that exemption. But it also means, and it's intended to create flexibility in dealing with difficult situations. So as Raman mentioned, age-related mental decline happening in an aging demographic impacts these things. And so these power of attorney tools, enduring and continuing of your Quebec protection mandates, are all designed by legislatures to be flexible tools to deal with these scenarios as they arise. So I highlight that so that when we return to the conversation around when the abuse of powers of attorney, you keep in mind that these are exemptions that are created by statute, and there's a reason for them. When power of attorney terminates on incapacity, it happens at a time precisely when somebody might need it. So if I granted a general power of attorney that was not on enduring or continuing, and then I'm fine today, it means that I can supervise the actions of the attorney. But the moment I lose capacity and I cannot supervise the actions of the attorney, that document dies unless it's enduring or continuing. And so the flexibility created by statute is to deal with that issue that the common law created. So let's talk about, again, focusing on the idea that a power of attorney is an instrument, it's a document and not a person. Desjardins, which is a TD Bank case, really, it's a BC case where the court says a power of attorney is an instrument, a document, not a person, authorizing an attorney to do anything that a donor could have done if she acted lawfully. Again, look at the definition of what a donor could do acting lawfully. And so I can grant Raman an attorney, a power of attorney that gives her powers beyond what I could do lawfully. And that will come up again in instances where I've signed contracts that limit my ability to do certain things. I can grant a power of attorney to somebody else who could then try to do the thing that I couldn't do personally. Power of attorney, an adult may authorize an attorney, and this is the language from the BC Act, to make decisions on behalf of the adult or do anything that the adult may lawfully do by an agent, again, in relation to the adult's financial relationship. Here, I've highlighted the term agent because the idea is that the attorney acts on behalf of the donor, right? You're acting on my behalf. And so, again, when we get to issues of exploitation and abuse, sometimes the attorney tries to impose themselves and limit the ability of the donor to interfere with the decisions that the attorney is making. Here, the BC Act, and then you find some similar language in the Ontario Act, really highlights that the attorney is acting on behalf of the donor. And really, the donor, if capable, can rescind or revoke the authority of the attorney. So again, highlighting, so going through that, it's really to kind of highlight for you that provincial law that creates enduring and continuing power of attorney are intended to create flexibility and to allow powers of attorney to be used in creative ways to deal with the issues around aging and the loss of capacity. But with that flexibility also comes risk of issues around litigation, because actions by an attorney may be misunderstood, the family dynamics and disputes that Raman highlighted in her introduction, and the issues around the capacity of the donor when they grant these documents come into question. So we've solved one problem, which is a great solution, but that solution is not without its challenges. And that a lot of us, when we're dealing with the misuse of powers of attorney, is because of the flexibility we have on the statute that creates those issues. Financial abuse of elderly and senior Canadians is becoming more prevalent as we're aging. Raising rates of dementia and other ailments are affecting our capacity. which means that as we're getting older, a lot of issues around mismanagement and abuse of our assets by family members or third parties are becoming increasingly prevalent. Enduring power of attorneys may be subject to the most abuse when a donor is incapable, when a donor is no longer able to oversee the actions of the attorney, and the donor may not be able to revoke those powers. So you can see the vulnerability that is in that circumstances when I'm incapable after I've granted that document, so I can't oversee the actions of the attorney, and I can't revoke the document that grants the authority. Based on our practices, what we generally really see a lot is the issues of dispute arises because an attorney's treatment of or dealings under a jointly held asset of the account with a donor becomes a fight, or there's a dispute around that. There's disputes around attorney's misappropriation of a donor's assets, often disputes between siblings or family members regarding capacity or incapacity of a parent or the donor in some instances. An attorney disputes between siblings about whether mom meant for our attorney to be able to make gifts or do other things that the attorney is doing. And then disputes regarding whether it was the donor or the attorney who acted in a given stage, where both the donor and the attorney are acting. That becomes really an interesting issue when you have multiple powers of attorney that are being revoked, or that, and then a new one is being put in place, is appointing different people. The donor is kind of capable and is also dealing with transactions at the same time. Those issues, when Raman will be talking about things about accounting and really when the donor dies, usually these issues rise up because there's issues around who did what, were they acting, what capacity were they acting in, and how does this affect whether this was an exploitation by an attorney. So I will stop here, and if there's any questions around kind of the quick overview of what a power of attorney is, why it's important, I'm happy to take them. And if not, then I'll invite Raman to walk us through the duties and responsibilities of an attorney.
I don't see any questions, but Raphael, I believe you were doing this section.
Oh, my apologies. I'll keep going.
Okay.
So the first part of what I've discussed is really to set the basis for why we use powers of attorney, why issues of risk and disputes emerge. The duties and responsibilities of an attorney, it's really, hopefully, is to give you a context of how we deal, why when responding to misuse of powers of attorney, the context in which you have to consider those, and you have to kind of do your analysis about whether the attorney is acting properly or inappropriately in some manner. So the first piece is compensation, which comes up when an attorney is taking fees or something like that because of what they think is compensation due to them. And what I want to highlight is an attorney must exercise the care, skill, and diligence as is usual in or necessary for the proper conduct of an attorney's business. That if you're not receiving compensation, then really the standard you have to meet is display the same skill, care, and diligence that you would use in conducting your own affairs, right? So if I'm not taking compensation, then it's how the skill and care that I will use to manage my own stuff. If I'm in a business of being an attorney and I'm taking compensation, then the standard is different. The reason why that matters is sometimes when you are put in a position of either claiming compensation as an attorney or seeing if what you're being asked to pay out as compensation is reasonable and they haven't gone through an accounting or anything like that, this is the standard that applies. Again, this is just to give you context around how these things are shaped. Fiduciaries, a fiduciary duty to act in the best interest of an attorney, so of the donor. So an attorney has a fiduciary obligation and duty to act in the best interest of the donor. Sometimes that becomes difficult to assess as you're dealing with your financial institution or being asked to execute on certain instructions. But roughly, you want to make sure that the attorney's actions are reflecting the best interest of the donor to the extent possible for you to know. May not exercise the power for the personal benefit. An attorney may not exercise the power given to them for their own personal benefit unless the donor is capable and consents with full knowledge of what the transaction is, or unless the power of attorney expressly authorizes the attorney to do so. So for example, in my practice I've seen a lot is a question that comes up is an attorney wants to make a gift of the donor's assets to themselves. And are they authorized to do that? One is if the donor is capable and is consenting and has full knowledge of what the gift is, then perfect. It's just that you don't really even need the power of attorney in that way. But where the donor is not consenting or is not capable, doesn't have full knowledge, does a document authorize that gift? So the document says Raphael may make a gift to himself, even though he's acting as my attorney. Like, if that says that, then it's expressly contemplating that transaction or that gift could be made. And so for in terms of personal benefit, we always want to make sure that the document is what we're relying on, or if the donor is capable, then we get the donor's full consent and that we are aware that we can assure ourselves that they have full knowledge of what the transaction is. Where the donor does not have capacity, certain issues arise and we have to pay attention to those. Because when a donor is lacking capacity or starting to lose capacity, the donor becomes more dependent or reliant on the actions of the attorney, right? And so absent a specific provision in the document that says an attorney can act in a particular way that involves self-dealing or a gift to the attorney, you want to be careful that you're not relying on attorney's direction alone, where the action benefits the attorney. It is an attorney's duty when there is incapacity to use the power granted to that by the donor solely for the benefit of the donor and not for the attorney's own profit, benefit, or advantage. And so when you have suspicion or you have evidence that the capacity of the donor is in question and the document doesn't expressly provide for certain transactions that may benefit the attorney directly, I think this is good guidance on how you ought to consider whether you should give effect to direct instruction of an attorney for that benefits the attorney. Power of attorney regulations. Record keeping obligations on attorney must make, attorneys have to account for the actions, and this will come up again in conversation. And so you want an attorney to make reasonable effort to identify properties and liabilities, maintain a current list of property and liabilities, and keep records for the attorney's own sake and for the transactions they're doing. So when if I've had files where we're tracking whether the attorneys acted properly, and there's no record on which to rely on transactions that attorneys purpose have completed on behalf of a donor. That is an issue. If they're going through, you can force an accounting and get some of these records and some of these issues, but really what we want is an attorney, if you're acting as an attorney or if you're advising an attorney, is to make sure that they're keeping and maintain a current list of property and liabilities, and they're keeping records of transactions that they're engaging in. Finally, what we want to explore is restrictions on the powers an attorney can have. In addition to any express limitations in a document, which earlier I mentioned that you can have, a power of attorney can be limited in terms of subject matter. So I can say you're only dealing with Raphael's account at Scotiabank or at TD. That is an express limitation in a document with respect to the subject matter that the attorney can engage in. You can also include in this kind of the restrictions of an attorney's powers, the common law restrictions that come along with powers that are delegated. For example, the other piece that you should consider is the example I gave earlier, where the donor has signed a contract that limits what the donor can do with a certain property. If I appoint an attorney, that attorney is also impacted by the extent of that restriction. As we talked about, attorney not acting, not self-dealing or acting in conflict of interest, although the document can especially remove that. Donor cannot give the full authority to an attorney. These are the common law restriction that says, I cannot grant or delegate to another person my testamentary power. So I cannot have an attorney make a will for me. I cannot have an attorney make a disposition of property that happens on my death. There's a question around beneficiary designations, and that in some instances, the courts have had debate around whether a beneficiary designation can be made by an attorney. Increasingly, based on actual advocacy by a lot of the big banks, provincial legislators have come up with statute. The BC is one of the best examples of this, where an attorney is now granted a limited scope to make a beneficiary designation on behalf of a donor, which is if it's an RSP, for example, that's renewing or converting, you can name the same beneficiary that was on the existing existing investment when it converts over, or you can go get a court order to do it. That is because of this issue, that you cannot delegate to an attorney the power to make a testamentary disposition. You can also not delegate to an attorney duties that you have to perform personally. So if I'm a trustee of a trust and I'm supposed to exercise my judgment and discretion, for example, to make decisions as to who gets money out of that trust, I cannot delegate that authority, right? It has to be exercised personally by Raphael, so I can delegate it to Raman to do it, unless the document, the authorizing document allows me to. But unless if it's expressed, if on the absent an express authority to do that, I cannot delegate to somebody powers that I have to perform personally. And finally, my power of attorney extinguishes on my death. And so it doesn't matter if I've given, it's valid and I've granted all the right authorities. I still, once I've died, that document extinguishes, it terminates, and that the power of attorney, the power of the attorney also terminates. So I will stop here to see if there's any questions, and then now I will pass it on to Robin.
Thanks, Raphael. With all that Raphael has talked about in terms of the function of powers of attorneys and the duties and responsibilities of attorneys, we can put it into context a bit when things go wrong and when people misuse their powers of attorney. So if you can just go to the next slide, please, Raphael. Basically, I don't think we'd have any issues with powers of attorney if there was no money involved. And usually the majority of these cases involve misappropriating the donor's funds or being alleged to have misappropriated the funds. Sometimes there are no funds to misappropriate, and these family dynamics just have always been kind of bubbling beneath the surface. And you give one child a power of attorney and it becomes cause to try and, find out what parents have. And they've spent their entire life being private about it and being independent. And so, giving one kid a power of attorney over others is problematic. More problematic in my mind, from what I've seen, is when parents decide to give two or more children powers of attorney or become joint executors, and they never got along in the first place. And so it's a ripe situation for disputes. When I talk to clients who are doing their planning, I ask if their kids get along, if they're intending on having them appointed jointly. And I think this is their way of hoping that their kids will get along, and inevitably it's not the case. I met with a few weeks ago, and I said, well, do your 3 kids get along? And they paused and kind of smirked. And I said, you don't need to say anything else, but I can tell from your reaction that they don't get along. And so that's where I send them off to consider the appointment of a trust company for, being the executor or the personal representative. And I think similarly for powers of attorney, it's something that clients, ours, should consider, where these frictions are already apparent before the parent loses capacity. So, like I said, it usually involves money. Sometimes it's, good intentions of the kids to protect the parent from themselves if they see a declining capacity, sometimes protect them from a late romance in life, but could be seen as them protecting their own inheritance. We will see that in a couple of these cases that I'm going to talk about. If the parent, let's just say it's a parent, still has capacity, they can certainly revoke their power of attorney. They can have access to information to know if their attorney has done something shady. But obviously these things arise when they start to lose capacity. And as we know, it's not a black and white issue. There's a lot of gray. And Raphael alluded earlier that there's often situations where there's multiple powers of attorney, and trying to kind of wade through that mess becomes quite difficult when you start engaging in litigation. And one of these cases was Egley and Egley. So Mr. Egley and his wife had 2 children, 2 sons, David and Gerald. Gerald had a disability that, required him to be placed into care later on in life. And David lived out of province. And I think that's important to remember when we go through these facts. The will of Dad was 50-50 between both sons. Mom passed away. Dad gave power of attorney to David in '94, which was under Alberta legislation. He moved over here, I guess, or I don't know why he had an Alberta actually, but in '98, he gave him another power of attorney. And then Dad, apparently during that time after Mom passed away, was living his best life, traveling a lot. And then in 1999, his he starts to decline, and he's placed into an intermediate care facility where he's pretty independent for the most of it. But at some point in 2001, the public guardian and trustee declares him incapable through a certificate of incapability, which they can do quite easily. It's questionable why, David wasn't brought into the fold there. I suspect it was because he was out of province. But in any event, the public guardian becomes committee of Hans's finances and starts to investigate some of these transactions that David had done in the interim. And so broadly, those transactions are: one, transferring the family home into the name of David, David's wife, and dad, so that there was a right of survivorship. And when dad passed away, it would fall jointly to David and his wife. And two was transferring 2 investment accounts to himself, which is David, his wife, and his children as beneficiaries. And so the PGT came after David for both of these transactions. And as is the case, everything turns on the evidence. There's evidence of the caregivers in this facility where dad was living, doctors, a lawyer, and, the son, David, was just saying, listen, I wasn't doing anything shady. I was just repackaging dad's wishes. And effectively, dad had always said that he wanted me and my family to receive. And there was problems with this. There was no evidence through paperwork anyways, that dad wanted everything to go to David and his wife and children. And two, you've got this son, Gerald, who has a disability. And so prior to dad passing away, and he had created a disability trust, a discretionary trust for his son, and Gerald. And then at some point, there's the allegation that David has dissipated the entire estate by transferring the house to himself and these investments to himself, such that there's nothing left for Gerald. The counter argument is, well, Gerald wasn't able to accept this because he would have lost his government-funded disability benefits. At the end of the day, the lawyer who drafted the power of attorney had evidence that dad did want David to take over the family home. And I guess it was evidenced by the fact that David did move back into the family home, which you can see either way is supporting or not supporting that intention. But the judge was satisfied enough that there was evidence corroborating the intention dad had to gift the house to David. There's no such evidence with respect to the investments. And like I said, they, exhausted the estate such that Gerald was left without anything. And so the court said, given that, these investment accounts go back into the estate and are available to Gerald. And so that was an example of the court kind of jumping between certain transactions. They went through a lengthy discussion on the threshold for having the capacity to execute a power of attorney. They never quite came out and said that dad was incapable when he executed that power of attorney, although there was quite a lot of evidence that he probably was. And at the end of the day, they kind of cut the baby in half by saying, keep the house, but not the investment accounts. So next slide, please, Raphael. Bridger is another family situation. This is the blended family, which I always pay close attention to, being a stepmother and second wife myself. And there's too many fairy tales with bad stepmothers. So I always take a personal interest in these. So we've got Jack, the husband, dad, deceased. He granted a power of attorney to his second wife, Julia. And I should mention, Julia was married to him for 40 years. So it's not, one of these second marriages late in life that is very short term. It's quite a long marriage. Each of them came with their own 3 children. And by the time this whole issue arose about power of attorney, the 6 children were capable adults. I should say during the marriage, Jack and Julia kept their finances pretty separate, and had been pretty clear that he would get what was his and she would get what was hers. They even executed wills to that effect. She had owned the property that they lived in as their marital home prior to the marriage. During the marriage, she bought another rental property on her own and managed that. They eventually bought a second property, or she and he jointly, putting in the down payment and then managing that. And what happened was he became older. She says, I can't manage these properties on my own. So she sells a couple of them, puts the proceeds of sale into the bank account, and it's a joint bank account with right of survivorship. give some gifts to her own children from her first marriage, which were, 130 grand, not too shabby. And then her husband passed away and she, kept those through right of survivorship. Under his will, he didn't leave the wife anything, I guess, along with the pattern that they had kept things separate during the course of their lengthy marriage. She implemented a wills variation action. And I feel like she should have just left well enough alone because she'd already gotten the funds from the sale of these homes. And so when she implemented that, the daughters of dad, his adult daughters, counterclaimed against second wife, seeking an accounting for these funds from the sale of these properties. You can go to the next, oh, there you go. And so, like I said, she should have left well enough alone. The court did give her 25% of the estate, which was smaller than anticipated because she had already taken some funds out. And she appealed that portion of it, which didn't reflect the accounts. And, at the end of the day, the court decided that dad/husband's dementia was so bad when he signed the power of attorney that he wouldn't have been able to have capacity to do what he did. In that event, and if she was even the attorney, she owed him a fiduciary duty with respect to her dealings in his affairs, going back to what Raphael was talking about. And so the judge basically said half of the proceeds of the sale of the two properties are impressed with a trust. And so those are still the husband's, and wife keeps her share. And so that was an interesting way to decide on something. I don't know if that's rightly decided, whereas I do agree with the first case, Egley, that it was. Because it seemed like the wife was really managing the properties and had put most of the funds in, but needless to say, she lost out on that one. So Zelegs is similar to the one we talked about. Mother and daughter held a house in joint tenancy. And I should say, there wasn't a dispute about the fact that mom did transfer it into joint tenancy with daughter for no consideration. There was no allegation that she was incapable at that point. And the issue arose because Diana, the daughter, and mom had two daughters. So she used her power of attorney to sell the property, which she had gotten mortgages on, paid out those mortgages, and put the net proceeds of sale into a joint bank account. Interestingly, after mom passed away, Diana was the executor, and that joint account she recognized only belonged to mom. So what was in that joint account she shared in accordance with the will, but she had already, prior to mom passing away, taken out the sale proceeds minus the mortgage, which was repaid. This decision has an excellent explanation about joint tenancies and tenancies in common and when they're severed. And I won't bore you with that now, but essentially the court found that the property is rightly in joint tenancy. Diana was allowed to use the power of attorney to sell the property and put it into this joint account with her and mom. But when Diana took that money out of the joint account, the sale proceeds that remained, she had effectively severed the joint tenancy, which meant, portion to mom, a portion to Diana. And that's kind of an interesting way of looking at things. And that happens more and more. And I think there's another case I'll mention that talks about that. The other thing that I found interesting about this was that, there's the sister who remained, her husband brought the action here because the sister passed away as well. And so the husband of the sister who passed away after mom brought the action in his wife's name against Diana and her husband, who used the proceeds of sale to buy another investment property and use the funds, which the court found were impressed with certain trusts requiring them to be clawed back into the estate. So the next slide, Raphael, is kind of interesting to me in the sense that mom had 8 children, and that's fascinating enough to have 8 children. And she had given 2 of those kids, so she had 6 daughters, 2 boys, power of attorney. And prior to mom passing away, those daughters decided to, make advances, gifts that totaled $880,000 to all 8 children. And all 8 children accepted those gifts. And that was a hugely questionable transaction, but since everybody agreed, it didn't come to light. It only came to light when mom lost capacity and there was a dispute between the siblings on who should be appointed her committee. So we had 3 girls who wanted to be appointed, women who wanted to be appointed committee. The other 3 sisters supported those sisters. 2 brothers said, "Nuh-uh, we as brothers, we should be appointed as committee." When you make an application to court to have someone declared incapable and have yourself appointed as committee, which is fancy lingo for basically, another version of power of attorney, you have to give notice to the public guardian and trustee. And I think it's only that involvement by the public guardian and trustee which triggered this look at these transactions that 2 of the daughters used to make these significant gifts. Because remember, the sons agreed to those gifts. Obviously, they benefited them. And throughout this dispute over who should be committee, everybody agreed Mom was incapable. It was just who should be in charge of her finances and her needs. And the public guardian did not support the daughters because they had had incomplete financial disclosure from the daughters. And they didn't agree with the sons, but they didn't take a position. And very reluctantly does the public guardian say, we'll do it. It's only if no other family member is available. But in this case, they did say they would do it. The court appointed them. And the court basically said, we don't trust any of you. Whether it's brothers versus sisters is irrelevant. All of you took Mom's money when she was still around and might have needed it. And you don't know how long Mom's going to be around, and you don't know how much her care is going to cost. So taking $880,000 is, threatens her future care needs. And so none of you is appropriate or fiscally responsible. And they appointed the public guardian and trustee. Can you go to the next slide, please, Rhonda? Thanks. And so I mentioned before suspicions, and the Mulder case is one of those situations. We had Mom who had 3 kids, and she had reached out to a couple of them before she passed away, asking them to be her powers of attorney. Son declined, daughter agreed. Daughter had a history of accepting gifts from Mom. She was in financial need. Everybody knew about this. And here's another case where you have siblings with fractured relationships. Daughter also became beneficiary, obviously was beneficiary equally with her siblings, but she also became the executor. And so you always have this difficulty when if a power of attorney becomes an executor and you've got suspicions from the beneficiaries, there used to be a hard line that the executor is responsible for accounting from the date of death. And that before the date of death, it's basically no one's business what happened. But more and more, when you have situations where the power of attorney is also the executor, the siblings, beneficiaries want information about what that person might have done before Mom passed away. Here, interestingly, the daughter never actually used the power of attorney. But I bring this case up because the court talks about this, how this litigation proceeded. And there were tensions when Mom passed away over, what happened and who got what. And to her credit, I think the executor / sister, daughter, was trying to address the requests from one brother in particular. And that was the brother that had actually declined to be the power of attorney. And I imagine at some point, this is me trying to delve into the psyche of people, she just got fed up with them. And she thought these inquiries are really just annoying me and unnecessary. Or maybe she had something to hide. We never know. But at some point, she put a stop to it and said, I'm not giving you this pre-death disclosure. I never used the power of attorney. Leave me alone. And so the court talked about this nuclear option versus passing of accounts. When the sister put a stop to these requests, or specifically with respect to the pre-death accounts, the judge said the son chose the nuclear option, which was to litigate. And the expense and the costs of litigators and lawyers was just exceptional. And the alternative is to ask the executor to pass their accounts, which is much more, formatted in how you deal with that with the rules of court. You still have to go to court though. Get a court order that you have an order that they produce documents related to pre-death information. And so there's those 2 options. Unfortunately, they chose the nuclear option here, which led to years of dispute and costs. And like I said, it wasn't an issue of her using a power of attorney before death, but there's an interesting discussion on when it is that a court will order disclosure of pre-death clinical records, I guess, and financial records. And here it was that history of her receiving gifts It was her having financial difficulties, which everyone was aware of, and raising the bar of suspicion enough that the court wanted to give disclosure. So the final case I'm just going to mention is Kramer and Kramer. It was decided just a couple of months ago. It was mostly in relation to an alter ego trust. And I mentioned this case because it was a situation where mom had 2 daughters and provided for them unequally in the will. And so the daughter, who was the power of attorney, decided to settle an alter ego trust on the same terms as mom's will. And that is allowed. But the effect of that was that those assets that were put into trust were outside of the estate. And when the daughter, who was provided for unequally or less, tried to bring a will's variation, she wasn't able to access that because those assets went into the trust. And so what she has to do is try to get the trust set aside so those assets can be put back into the estate, and so she can seek a variation. And her method of doing so here was a fraudulent conveyance act. She alleged that she had a debt owing to her, and that she was a creditor. And so the court put all that aside. But it was interesting to see that the court did again, and there's very few cases on this, but they did again accept that it's legitimate estate planning for an attorney to settle an alter ego trust. It has to be on the same terms as the donor's will, though. But here the effect was that the assets were outside of the reach of the daughter under a Wills Variation Act claim. Just go to the next slide, please. So I mentioned committeeships with the U case just briefly. Raphael mentioned powers of attorney, they have to be accountable for all transactions. And I had said it becomes difficult when the executor is the same person as the attorney, because you don't really have anyone to give a true accounting. And so in that situation, you have the option of nuclear path or an accounting. And, I always say, and I know Raphael agrees, that where there's any possibility of dispute, appoint somebody neutral. A third party trust company is usually the best bet. They don't have that emotionality, but they'll tell you too that they get embroiled in this as well. And any suspicions are going to be leveled against all sorts of individuals, whether they're a neutral party or not. But it's, it hopefully reduces some tension at least, because the emotionality of this, I find, is more so the driving force on why these disputes arise. So do you mind going to the next slide for me? And this is my last slide, Raphael. How to deal with the misuse of powers of attorney. And I've kind of glanced through these 3 things broadly anyways. But if the donor is still capable, they have the right to revoke a power of attorney. They have a right to look at their own transactions and see what the attorney may have done. Usually it's an issue of declining capacity. And our courts have, have kind of jumped around the issue, but they have said adults are able to make bad decisions. So even if you think you're protecting, the donor, the parent, or whomever, from themselves or from others, dad getting married at 80 to somebody who's 40 years old and showering them with gifts might not be prudent, and it might be upsetting to the children, but they're allowed to make those decisions. If they become incapable, I guess the plan is to try and have somebody become committee so they can look into the transactions of the attorney. Once they pass away, you've got the representative, either an administrator or an executor, who has the ability to go back and find information out to see whether or not an attorney was complying with their fiduciary obligations. And the last would be beneficiaries, which is a bit more legwork. Beneficiary of an estate, they aren't directly allowed to take action against an attorney. They would have to go to court, get approval under Section 151 of the Wills, Estates and Succession Act, so that they can bring an action against a party who's usually the executor, who is also the donor. So, litigation, which is most of these steps, isn't ideal. And certainly there's workarounds and some informal mechanisms, which Raphael will speak to with respect to financial institutions and some of their techniques. Raphael?
Thanks, Roman. Before I start, there's a few questions for you, so let me pose them. First one says, I'm the attorney for my mother for both financial as well as health. under a living will. She lives in Quebec. We were told by the lawyer that we could not have both my brother and I as attorneys, and that she could only have one.
So, I
Yeah.
mean, I can't speak to Quebec. I find that highly unusual. Maybe that person was taking instructions from your mom who might have known that there was a potential for some disagreement. I can't speak to Quebec. But I can speak as, sorry, were you gonna say, Martha?
I was going to say, yeah, I can't speak to Quebec, but it seems like other than practical reasons, maybe getting to the bank or something like that, I wouldn't see any rationale why you couldn't have joint attorneys.
Yeah. And remember, it's not the lawyer who's, the lawyer's the legal expert, but the instructions come from mom. And so I suspect those instructions came from mom, or there was some residency issues or something like that might have made it impractical, like Raphael said. So I can see these now. So let me just see. Egley and Egley. How would anyone find out that the attorney helped themselves until there was a joint POA? How do other potential beneficiaries ensure that there's no funny business with regard to the power of attorney? So that's the difficulty that arises if, if the donor is still alive and capable, even if it's a gray area, they're the only person who can, get that information. The beneficiary, I guess, if the person is still alive, is to, if there's enough evidence that they're incapable, they go to court and get a declaration that that person's incapable and apply to become the committee. And if they become committee, they have access to that information. And then I guess the third is when the person passes away, you would apply as a beneficiary under section 151 to be able to bring a claim, but you could also just wait out and ask for a passing of accounts from the executor, who I'm assuming here is the power of attorney. So you basically have to have standing. You have to have the ability to look into it as either the donor, their representative, or the beneficiary through a court order. And so I think that's the same person unless there's joint power of attorney. As a power of attorney, what expenses are you allowed to claim against the estate? So usually that is, and I'll let Raphael speak to this after, but usually the powers of attorney that I make are that they can reimburse themselves for legitimate expenses. And you have to look at, I guess, what the reasonableness of those expenses are. And if they aren't paid back before the donor passes away, the executor would have to look at those and see if they're a reasonable debt against the estate. And if they're significant, we have to look into, whether or not they were authorized and whether they're for the benefit of the donor. Troy, did the dad have a will? I don't know which that one refers to, but I think in most of the cases I talked about, the donor / parent had a will, and Egley, dad had a will, and he left it equally between his two sons. The one son who had a disability, it was a discretionary trust. So I hope that answers your question, Troy, but if it doesn't, let me know. Can the current power of attorney request any financial records of the former power of attorney? Well, hopefully it's clear who is the power of attorney at the time and the prior was revoked, but you're basically standing in the shoes of the donor, and you can go back as far as you want to get information related to the donor's accounts directly from, I would say, the financial institutions. And the former power of attorney would have an obligation to keep an accounting. And so hopefully they provide information, and if they don't, you can get that information through the financial records through the institutions. But Raphael, I'll let you speak to any of those things.
Thank you. So in the interest of time, I had a couple of comments on the questions, but I'll move on. And if anyone has a follow-up, either shoot those questions to me, to us in the chat, or feel free to engage Robin or I with in an email. But I really wanted to pivot, because a lot of the audience are from financial institutions, to what's the role of a financial institution or an advisor, investment or insurance advisor, in this context when you're dealing with the misuse of a power of attorney. The cases that are available that speak to this in terms of responsibilities really speaks to the role of a banker. But my argument to you is that you could read that and posit that the role of the banker, you can analogize it to an investment advisor, insurance advisor in this context. So what is then your responsibility? And a lot of the cases says it's based on making reasonable and honest inquiries based on your relationship with the client, right? So knowing what's the facts? What are the facts you know about the donor in this case, and if anything about the attorney? And then do they have the requisite authority to act before allowing the attorney to act on behalf of the donor? So one is find out what do you know about the client, the donor, and the attorneys, and then based on that and the document you have, did they have the requisite authority to act? There's no real statement of law on what a reasonable banker is, other than the one case that says a reasonable banker will make these inquiries. So I would I'll posit that to answer those questions, you have to look at whether there's industry regulations or other laws that impact what a reasonable insurance advisor, investment advisor, banker in the circumstances would do. There's now an emerging kind of sense of regulations that says, if you're in this industry, so in banking, you have the seniors code that gives you some sense of what might be required around POA. In investment advisor, you have the amendments to the National Instrument 31103 that talks about a bit about what you would do around exploitation, but there's no real standard. So the question then will be, is there industry practices? If you're working as part of a big bank or big investment firm, you have standards as an industry that will impact what your reasonable obligations are when you suspect that there is exploitation by an attorney. Again, these are all still emerging, so there's no kind of formal standard that we could point to. So it makes the last word the most important part because of because of reputational issues around exploitations, and as Canadians get older, as well as because of the emerging regulatory landscape, a lot of banks, investment firms, other industries are now starting to put in place practices around how you deal with potential exploitation. To me, that is the standard that a court's likely to hold you to if you read the case law, because there's no concrete standards. So one, does your institution have internal practices and procedures around somebody shows up with a POA, how you determine it's valid? What kind of authority do they have? Are the transactions they're asking you to facilitate one that is authorized under the document? Do you have procedures around that? If you do, you have to live by those standards. So let's look at some case law that helps hopefully lead you to the same conclusions that I've drawn. So in Citadel, the Supreme Court of Canada says a bank's knowledge of its customers' affairs will require the bank to make inquiries as to the possible misappropriation of trust funds. When you're dealing with a client that is a donor that's incapable, whose assets are being managed by an attorney on their behalf, you're in a realm akin to a trust. The other piece is, what is the industry standards? Is there regulations that impact you? Since 2019, when I started really seriously getting involved in this area of work, this is just a brief list of what's come out in terms of the regulatory standards that are starting to impact financial institutions, advisors around their obligations around vulnerability, and in particular, other financial exploitation. So there is kind of a coalescence, a vision of what obligations that advisors in financial institutions have to live by, but it's still not solidified yet. So based on what sector you're in, you have to be aware of what's happening, and then you have to be particularly aware of what your internal policies and procedures are. Why is that important? There's a case, Ontario versus TD Bank, where the court looked at what TD Bank's internal procedures were in determining whether they lived by them and whether they were liable for misappropriation of funds using the power of attorney. So in that case, the court actually looked at the internal procedures, which were designed to prevent the exact situation that happened, and said you didn't live to that standard. Right? And so since we don't have formal objective standards, it's really all of us have to pay critical attention to what our internal standards are and make sure that in all cases we're living by what those standards are. Once a financial institution, this is what I was referring to earlier, which is once as a financial institution you are dealing with an incapable or potentially vulnerable donor, what you're operating in is a space you're dealing with somebody that's acting akin to what a trustee does in relation to trust funds. So you're managing somebody else's money. And if you think about the practical reality of what's happening, it makes sense. if Raphael has a POA and he grants it to Raman, and then I lose capacity, I can never go back and change or revoke that POA. I can never supervise Raman's actions anymore. And so really while it's not a purely trust relationship, my incapacity creates an environment that makes it seem like that. And so I would argue, and I'll posit that increasingly when you look at the case law in this space, courts are starting to treat this circumstance where the client's incapable, the donor's incapable, and attorney's acting as if there's a trust relationship that exists. So what are some lessons to draw from this? Which is, unless as an FI you have reasonable basis to believe otherwise, you can presume that your client, who is an adult, is capable of managing their property or financial affairs and are acting out of their own free and informed thought. And if they are doing that, and you're presuming that, then they may make gifts. They may do transactions even if you don't think are prudent, as Raman highlighted. And they may authorize an attorney to engage in a transaction on their behalf, because again, they have the capacity to act and they can supervise the actions of that attorney. A client who lacks mental capacity that's required to manage their financial affairs or to grant a POA, or is potentially a victim of undue influence, and I haven't spent a lot of time talking about that because we are limited in time, may engage in a transaction or authorize an attorney to engage in a transaction that benefits the attorney. The only exception being that the client's they must be acting out of their own free and informed thought. They expressly authorize the attorney in writing to engage in that transaction. And they did that either in the POA or prior to losing capacity in a separate document that you can verify. And the attorney may, in that case, the attorney may engage in those activities or transactions. What to do if you have concerns? What to do if you have concerns that there's exploitation involved? One is go back to your internal procedure to make sure that whatever you have in place as an institution, you're living by them. If the client's mentally capable, as Raman pointed out, verify with the client, right? Because the client's capable, they can authorize, they can say, I want this to happen. If not, you pause. And you pause on the transaction, you investigate the matter further. What to do if you have concerns? Does the attorney want to engage in a transaction for the benefit of the attorney? That's a good question to ask. Or is it for somebody else? Did the donor expressly authorize the attorney in writing to engage in that transaction? Do you have a reason to suspect that the client may have lacked capacity required to grant that authorization, whether it's in a POA or a separate document? This all goes back to the idea that given the facts you know about your client, have I made reasonable inquiries? That's really so the nature of what the lessons that I'm hoping that you draw out of this is, based on what I know about my customer or my client or the donor, what questions should I be asking to verify that the transaction's permitted, the attorney's acting in a way that's permitted? How do you deal with these things? You leverage your internal resources. Always, if you have the ability to do so, place holds and report these functions up so that they're investigated properly. Increase contact with your older clients, either through personal meetings, frequent contacts, to make sure that capacity is not an issue for them in a way that will impact you. And then be vigilant where an attorney is acting or a committee or guardian is acting. We've been using the word committee a lot because we're speaking from BC, but this would be similar to guardianship in Ontario, trusteeship in Alberta, tutorship in Quebec. Tools for reasonably responding to financial affairs. Train your staff. If you're in investment world, the National Instrument 31103 required you to train your staff, but this means ongoing training because these issues evolve and are dynamic, and so you're going to see different scenarios. The other piece is educate your clients about the risk of exploitations and the resources to prevent them. That means putting in place powers of attorney that are thoughtful, that are intentional, that address the client's specific circumstances. As Raman pointed out, if the client's children don't get along, you don't name them all together to act together. Involve third parties. If you're dealing with a situation where there is risk, there is concerns of vulnerability or exploitation, are you able to use a supportive decision maker to verify that the client's willing to do what they want to do? If there's clear exploitation, is there a basis for referring to law enforcement, for example? Involve third parties in resolving these issues. As a financial institution, as an advisor, as a banker, you're not equipped to deal with everything. You need to bring in resources so that you can help decide and alleviate kind of potential exploitation issues. Almost always delay disbursements until you're comfortable, that you've assured yourself that your obligations are met and that you have explored whether the transaction is something that's authorized under the document. Remember always from the beginning that a power of attorney is a document. The individual is an attorney, right? And the document is what you refer to if the client's incapable. If the client's capable, you go to the client. The attorney can give you instructions provided that they are reflected in a document. What are some tools to respond? Informal responses is, again, helping your customers and your clients do advanced planning so that, and thinking through who an attorney is. Is this somebody I trust that will act for my benefit if I lose capacity? Do I need to put certain assets in trust if I think I want to protect them and shield them for somebody else? One of the cases, I believe was you, involved going to a public guardian trustee to get them involved. So really looking at what options are available to you to resolve these issues. There's no one-size-fits-all resolution. So what I hope you get out of this presentation, if you're an advisor, financial institution, or banker, is that there are tools that are available to you, and how you use them depends on the set of facts you're dealing with. You know, if you might explore civil remedies to apply for committeeship or guardianship, similar to the examples that Raman spoke to. And finally, there is criminal law provisions that deal with exploitation by powers of attorney. And so you can look at those to see if the police need to be involved, and you can engage criminal remedies. So I'll stop there in the interest of time, and then see, I believe there are a few questions, and then we'll wrap up, seeing that we're over time a bit.
I think, Raphael, maybe we'll just ask anyone with questions to reach out to us personally, because we've taken a few minutes away from folks by going over. So on behalf of Raphael and I and Gowling, thank you so much for attending this webinar with us. Please respond to an email you'll get, I think in the next week or so, with any comments or concerns or suggestions even for other seminars that you'd like to see. And as always, Raphael and I remain resources for any questions or things you might want to kind of get a second look at. So with that in mind, yeah.
So I just want to highlight that there's a QR code. If you scan it, it'll take you to a survey that you can complete. Let us know exactly what Raman is asking. So feel free to scan it and reach out to us. And thank you so much for joining us.
Take care, everyone. Enjoy the rest of your day.